A new law is moving through the system right now, and your phone is already being used as evidence against you without your knowledge, without your consent, and in many cases without a warrant. Not a theory, not speculation. Court documents, active legislation, and law enforcement requests filed in federal court are showing exactly how this is happening. And the legal framework being built around it is something every American with a smartphone needs to understand before it is too late to matter. This affects iPhone users, Android users, people who have never been arrested, people who have never been investigated, people who simply live their lives, carry their phones, and assume that what happens on their personal device stays private. That assumption is being legally dismantled right now, and most people have absolutely no idea it is happening. Here's what makes this moment different from every other privacy conversation you have heard before. Previous debates were about what the government could theoretically do. What we are seeing now is what they are actually doing, backed by new legal arguments, new technology, and in some states, new legislation that has already been signed into law. If you carry a phone, if your children carry a phone, if anyone in your household owns a smartphone, you need to stay right here, because what I am about to walk you through changes how you think about your device from this moment forward. But before we go any further, are you subscribed? Hit that subscribe button right now and turn on all notifications, because legal updates like this one are moving fast and you cannot afford to be behind on them. Tap subscribe before we go 1 second further. Now let me show you exactly what is happening, how it works, and what you can legally do about it, because there is something you can do, but only if you understand the system being built around you first. Let me tell you about a man named Robert Williams. Robert lived in Detroit, Michigan. He had no criminal record. He was a father. He went to work, came home, raised his kids, and carried a smartphone like almost every adult in America does. In January 2020, Detroit police officers came to his home, handcuffed him in front of his wife and daughters, and arrested him for a robbery he did not commit. The evidence against him? A facial recognition match pulled from surveillance footage, run against a database that included photos pulled from his phone and social media accounts, processed by an algorithm that the police department's own vendor had warned was not reliable on darker-skinned faces. Robert Williams spent the night in jail. It took over a year for the case to be dropped. His phone, his image, his digital identity had been processed, analyzed, and used to place him at a crime scene he was never at. No warrant had been obtained for his biometric data. The algorithm made a decision. Police acted on it. A man's life was upended. Robert Williams fought back. He filed suit. His case became one of the most important civil liberties cases involving digital surveillance in recent American history. And what came out of it is something every person in this country needs to hear. Because Robert Williams was not a target. He was a data point. His phone made him one. And the laws being written right now are designed to make sure that what happened to Robert Williams can happen faster, more efficiently, and with even less judicial oversight than it had before. Hold that thought, because in just a moment, I am going to show you the specific legal mechanism being used to turn your phone into a witness against you. But first, do you think Americans fully understand how their phone data is being used by law enforcement right now? Drop your answer in the comments below and tell me what you think. And while you are down there, hit that like button, because it helps this information reach people who genuinely need to hear it today. Let me break down the legal landscape for you right now in the clearest possible terms, because this is where most coverage gets either too technical or too vague, and you deserve neither. The Fourth Amendment of the Constitution protects you from unreasonable searches and seizures. You already know this. But here is what most people do not know. The courts have spent decades carving out exceptions to that protection, specifically when it comes to digital data, and those exceptions have grown into something the founders of this country would not recognize. It started with a legal concept called the third-party doctrine. The third-party doctrine says that when you voluntarily share information with a third party, you lose your Fourth Amendment protection over that information. The government can then obtain it from that third party without a warrant. When the Supreme Court first established this doctrine, the idea of a third party was straightforward. If you told your banker something, you assumed the risk that your banker might tell someone else. If you made a phone call from a landline and the phone company kept a record of what numbers you dialed, the government could get those records without asking a judge. That logic was written for a world where people interacted with maybe a handful of third parties in their daily lives. Now apply it to your smartphone. Every day your phone shares your location with your carrier, your apps, your operating system, and dozens of advertising networks. It shares your browsing history, your search terms, your purchase patterns, your sleep schedule if you use a health app, your heart rate if you wear a connected device, your face if you use facial recognition to unlock your screen, and your voice if you use a virtual assistant. Under the third-party doctrine as it has been historically applied, the government's argument is simple. You chose to use those apps. You agreed to those terms of service. You voluntarily shared that information with those companies. Therefore, you have no reasonable expectation of privacy in any of it, and they can obtain it without a warrant. That is the legal framework that has been quietly expanding for years. But now something new is being added on top of it. And this is the part that changes everything. In multiple states right now, legislation has been passed or is actively moving that creates what legal scholars are calling mandatory data preservation orders directed at technology companies and telecommunications providers. Here is what that means in plain language. Previously, law enforcement had to identify a suspect, open an investigation, and then request data from a company about that specific person. The company could push back. Courts could get involved. There were at minimum some procedural speed bumps. What mandatory data preservation orders do is flip that sequence entirely. Under these frameworks, law enforcement can instruct a technology company to preserve the data of an individual before any formal investigation is opened, before any charges are filed, and in some structures, before the individual has done anything other than appear in a database or match a profile. The data gets frozen, the person has no idea, and by the time any legal challenge could be raised, the information has already been captured, stored, and made available for future use. Some of these orders come with gag provisions, meaning the technology company is legally prohibited from telling you that your data has been preserved and flagged, your phone keeps working, your apps keep running, your life looks completely normal, and somewhere in a server room, a frozen copy of your digital life is sitting in a folder with your name on it. This is not a hypothetical future scenario, this is the documented present. Federal law enforcement has used variations of this approach under the Stored Communications Act for years. What is new is the expansion of this logic at the state level, the broadening of what categories of data qualify, and the lowering of the threshold required to trigger a preservation order. The legal door that was cracked open by the third-party doctrine is now being kicked wide open by legislation that treats your phone as a continuously broadcasting surveillance device that you happen to carry voluntarily. And here is the piece most people are completely missing. Right now I want to introduce you to a specific legal instrument that represents the sharpest edge of this entire issue. It is called a geofence warrant, and it is the clearest example of how your phone is being used to spy on you without your knowledge, without your being a suspect, and often without any meaningful judicial oversight. Here is exactly how a geofence warrant works. Law enforcement identifies a location where a crime occurred and a time window when it happened. They then go to a judge and request a warrant ordering Google or another technology company that collects location data to produce a list of every device that was present within a geographic boundary around that location during that time window. Not a list of suspects, not a list of people who were investigated, a list of every phone, every device, every person who simply happened to be in that area. Your phone, if it was in that area, goes into that list. Your real identity is initially hidden behind a device identifier. But then law enforcement reviews the list, narrows it down, and requests that the company reveal the actual identities behind the devices they find interesting. You could have been walking your dog, you could have been picking up takeout, you could have been driving through an intersection. Your phone put you in a database of potential suspects without you ever knowing it happened. The Justice Department has used geofence warrants extensively. They were used in the investigation of the January 6th Capitol breach, pulling location data for thousands of individuals. They have been used in robbery investigations, in drug cases, and protests where law enforcement wanted to identify participants. A federal appeals court in Virginia ruled in 2024 that geofence warrants are unconstitutional under the Fourth Amendment, calling them the digital equivalent of demanding that everyone who walked past a crime scene hand over their papers for inspection. But that ruling applies only in that circuit. In other parts of the country, geofence warrants are still being issued and executed every single day. Your phone is the paper. Your location data is the papers they are demanding. And in most of the country, there is currently no binding law stopping it. Let me be very specific now because vague threats are not useful to you. Here are the 4 concrete mechanisms currently being used, documented in court filings and investigative reporting, through which your phone data is being accessed and weaponized. The first is carrier data requests. Your cellular carrier knows where you are at all times. Every tower your phone pings is logged. Law enforcement can request this data through a legal process called a subpoena, which has a lower standard than a warrant. In 2022 alone, the major carriers in the United States received hundreds of thousands of government requests for customer data. Most customers never found out. The second is app data purchases. Here's the one that will genuinely make your jaw drop. Law enforcement agencies at the federal and local level have been purchasing location data directly from data brokers, companies that buy raw location information from app developers and resell it in bulk. Because they are buying the data as a commercial transaction rather than demanding it through a legal process, they have argued that no warrant is required at all. You agreed to let a weather app or a coupon app access your location. That app sold your location to a broker. That broker sold it to law enforcement. The whole transaction happened outside of any court oversight whatsoever. The IRS, the DEA, the FBI, and multiple branches of the military have all been documented purchasing location data from commercial brokers. This is not a leak. This is not a hack. This is a legal purchase of information you did not know you were selling. The third is push notification surveillance. In late 2023, it was revealed through a Senate inquiry that federal law enforcement had been secretly ordering Apple and Google to hand over data about who received specific push notifications, what apps sent them, and what accounts were associated with those devices. Push notifications flow through Apple and Google servers before they reach your phone. That makes Apple and Google third parties under the doctrine we discussed earlier, and for years, gag orders prevented both companies from even telling their users this was happening. The fourth is the data that never leaves your device but gets taken anyway. Device extraction tools, sold by companies like Cellebrite and Grayshift, allow law enforcement to plug a cable into a seized or even borrowed phone and download its entire contents in minutes. Texts, deleted texts, emails, photos, location history, app data, passwords, all of it. These tools are being used by local police departments, not just federal agencies. And the legal standards for when and how they can be deployed are inconsistent, contested, and in many jurisdictions almost non-existent. These four channels are operating simultaneously. Your phone is broadcasting on all of them every single day. Now let me get precise about the legislative piece, because this is where the word forces in today's topic becomes legally accurate and not just rhetorical. The COSA legislation, the Kids Online Safety Act, has been discussed widely in the context of protecting children online. But buried within its data handling provisions are requirements that platforms retain detailed records of user behavior, communications patterns, and flagged content interactions. Those retention requirements create exactly the kind of preserved data reservoir that law enforcement can then access through existing legal channels. Several states, including Texas, Arkansas, and Utah, have passed laws requiring age verification for certain online platforms. Age verification requires identity confirmation. Identity confirmation requires linking your device to your real identity in a way that did not exist before. Once that link is established and held by a platform, it becomes accessible through the same legal channels as every other piece of third-party data. The most aggressive example is legislation that has been proposed and in some cases advanced at the state level, requiring telecommunications companies to affirmatively report certain categories of data to law enforcement agencies without waiting for a request, not provide it when asked. Affirmatively transmit it on a schedule or upon the occurrence of a defined trigger. That is the line between passive availability and active surveillance, and that line is being crossed in statute right now. When a law requires your phone company to send your data to the government rather than simply making it available upon request, your phone has legally become a surveillance instrument, not metaphorically, literally, by definition. That is what the word forces means in this context, and that is why it belongs in this conversation. Here is what this actually looks like in your life, and this is the part that matters most in this entire video. Understanding the threat is only useful if you know how to respond to it, and there are concrete, legal, constitutionally grounded things you can do right now that meaningfully reduce your exposure. The first is location data. Go into your phone settings right now, not tonight, right now, and audit every single app that has access to your location. The setting you want for almost every app is either never or only while using. There is almost no legitimate reason a flashlight app, a shopping app, or a game needs access to your location when you are not actively using it. Every app you set to never is one fewer stream of location data flowing into the commercial marketplace where law enforcement is shopping. The second is your advertising identifier. Both iPhone and Android have a setting that allows you to reset or completely opt out of your device's advertising identifier. This is the number that data brokers use to stitch together your behavior across different apps into a single profile. Resetting it regularly breaks that profile. Opting out entirely removes you from a significant portion of the commercial surveillance economy. On iPhone, it is in privacy settings under tracking. On Android, it is in Google settings under ads. These take 30 seconds, and most people have never touched them. The third is push notifications. Be selective about which apps you allow to send push notifications. Every app that sends you a push notification is interacting with Apple or Google servers in a way that, as we now know, can be subject to law enforcement requests. This does not mean eliminating all notifications. It means being intentional rather than defaulting to yes on every prompt. The fourth is understanding your rights at a device seizure. If law enforcement attempts to take your phone or asks you to unlock it, you have the right to refuse. The Supreme Court ruled in Riley v. California in 2014 that police need a warrant to search the contents of a cell phone incident to an arrest. That ruling was unanimous. Your phone is not like the contents of your pockets. It is more like your home. The Riley court said so explicitly. Do not unlock your phone for law enforcement without a warrant. Do not hand it over voluntarily without first speaking to an attorney. The fifth is encrypted communication. Apps like Signal use end-to-end encryption that even the company cannot access. If Signal cannot read your messages, it cannot hand them over, even if served with a legal demand. This is not about hiding wrongdoing. This is about having a private conversation the same way a conversation in your kitchen used to be private before your kitchen started carrying a networked computer in your pocket. Let me walk you through 3 scenarios that are realistic, documented, and that ordinary people are navigating right now. These are not scare stories. These are patterns pulled directly from court cases and investigative reporting. First scenario. You attend a political rally, a protest, a public event of any kind. Your phone is in your pocket. Law enforcement later requests a geofence warrant covering that location and time window. Your device identifier appears in the results. You are not a suspect in anything. You never did anything wrong. But your device goes into a database associated with that event. Months later, when you apply for a government job or a security clearance, that association exists in a data layer that investigators can access. What do you do with this information? At minimum, understand that your physical presence at any location is now digitally documented if you are carrying a phone. Know that geofence warrants exist. Know that your device identifier can be linked to your real identity. And if you are ever contacted by law enforcement in connection with an event you attended, speak to an attorney before you speak to anyone else. Second scenario. You are going through a difficult period in your life, maybe a divorce, a custody dispute, a contentious business separation. The other party's attorney files for discovery and, as part of that process, subpoenas your cellular carrier for location data. Your carrier complies. Your location history for the past 18 months is now in the hands of opposing counsel. Every late night you spent somewhere you claimed not to be. Every location that contradicts a statement you made, all of it reconstructed from the pings your phone made to cell towers while you slept. This is not a criminal proceeding. This is civil litigation. The legal standards are different and in many cases lower. Your carrier data is being used in divorce proceedings, child custody cases, and civil suits across the country right now. What you can do about this going forward is the same thing. Audit your location sharing, understand what your carrier holds, and if you are entering litigation of any kind, talk to your attorney about your digital footprint before the other side does. Third scenario. Your teenager uses a social media platform that, under a state age verification law, has linked their account to a confirmed identity. That platform is later served with a preservation order related to a broad investigation into content sharing on the platform. Your child's data, their messages, their connections, their behavioral patterns on the app get swept into that preservation order even though they are not the subject of any investigation. You are never notified. A copy of your child's digital life sits in a government-adjacent data store for a retention period determined by the statute. This is the scenario that keeps civil liberties attorneys up at night. Not because it is hypothetical, because it is already the logical and foreseeable consequence of legislation that has already been signed. What you can do is have an honest conversation with your children about what they post, who they connect with, and what their digital footprint looks like. Not as a fear tactic, but as the same kind of practical literacy you would give them about anything else in the world they have to navigate. Let me deal with the myths right now because they are circulating and they will leave you dangerously underprepared if you believe them without understanding the full picture. The first myth is that you have nothing to worry about if you have nothing to hide. This one gets repeated constantly and it misunderstands the issue entirely. Robert Williams had nothing to hide. He was still arrested and jailed based on his digital data. The question is not whether you are guilty. The question is whether the data about you is accurate, whether the systems processing it are reliable, and whether the legal framework governing its use is strong enough to protect you from error. Right now, the honest answer to all 3 of those questions carries significant uncertainty. Having nothing to hide does not protect you from having something wrong done to you. The second myth is that encrypted apps make you completely invisible to law enforcement. Encryption protects the content of your communications. It does not hide the fact that you are communicating, who you are communicating with, when you are communicating, or where you are when you do it. That metadata, the data about your data, is still available through carrier records, through the third-party doctrine, and through commercial data purchases. Encryption is a meaningful and worthwhile protection. It is not a cloak of invisibility, and treating it as one creates a false sense of security that leads to careless behavior elsewhere. The third myth is that these issues only affect people who are already in trouble with the law. Every expansion of surveillance law in American history has begun with a justification targeted at an obvious threat and then expanded from there. The tools built to fight one category of bad actor inevitably get applied more broadly over time. The legal framework being built right now around smartphone data does not have a switch that limits it to people who deserve scrutiny. It applies to everyone the data touches, which is everyone who carries a phone, which is almost everyone. The fourth myth is that the courts will sort this out before it matters. The courts are sorting it out. That process takes years. The Sixth Circuit ruled on geofence warrants one way. The Fourth Circuit ruled differently. The Supreme Court has not yet taken a definitive case on the full scope of digital surveillance under the Fourth Amendment in the smartphone era. While the courts deliberate, the data collection continues. Waiting for judicial resolution before thinking about your own digital privacy is the equivalent of waiting for a traffic safety ruling before deciding whether to wear a seatbelt. The risk is happening now. Here is the larger pattern you need to understand, and this is the piece that connects everything we have covered today. The legal framework around digital privacy is at a genuine inflection point right now. On one side, you have the third-party doctrine being used to justify the collection of smartphone data at a scale the doctrine was never designed to accommodate. You have commercial data markets that have created a parallel surveillance infrastructure that law enforcement can access without the procedural requirements of a formal legal demand. And you have legislation in multiple states actively building out mandatory reporting and data preservation requirements that treat your phone as an affirmative surveillance tool rather than a private communication device. On the other side, you have a Supreme Court that in Carpenter v. United States in 2018 took a significant step by ruling that accessing 7 days or more of cell site location data requires a warrant. That ruling acknowledged that the digital world requires a rethinking of how Fourth Amendment protections apply. It was a 5-4 decision, not unanimous, but it was a signal. You have lower court rulings on geofence warrants beginning to push back on the broadest applications of that tool. You have civil liberties organizations litigating aggressively on device extraction, on push notification surveillance, and on commercial data purchases by law enforcement. And you have increasingly, members of Congress on both sides of the aisle who are expressing concern about the scale of what is being built. The American Data Privacy and Protection Act has been debated. Various state-level privacy bills have passed in California, Colorado, Virginia, and elsewhere. The legislative pushback is real, even if it is incomplete. What this means for you is that the outcome of this moment is not yet determined. The framework being built can be challenged. It has been challenged successfully in specific instances. But those challenges require an informed citizenry, which is exactly what you are becoming right now by understanding what is actually happening. Rights do not usually disappear in a single dramatic moment. They disappear through a series of small legal expansions, each one justified by an obvious threat, each one building on the last until the accumulated exceptions swallow the rule entirely. The third-party doctrine was a reasonable legal principle for a world of landlines and paper bank statements. Applied to a smartphone in 2025, it is something else entirely. The people who understand that distinction are the people who can advocate for themselves, who can make informed choices about their technology, who can recognize when a legal request crosses a line, and who know what to do when it does. Let me bring this all home now, because I want you to walk away from this video with 3 things permanently locked into your memory. The first is the legal principle you must know. The third-party doctrine is the foundation of almost everything being done with your phone data right now. When you share information with an app, a carrier, or any technology company, courts have historically treated that information as no longer private for Fourth Amendment purposes. Understanding this principle tells you why the problem exists and why voluntary choices about what you share matter enormously. Every permission you grant is a legal decision, not just a technical one. The second is the practical knowledge that protects you. Riley v. California, decided unanimously by the Supreme Court in 2014, says police need a warrant to search the contents of your phone. Know that case, know that ruling. Say it clearly and calmly if your phone is ever demanded at a police encounter. You do not have to be confrontational, you have to be informed. I know my rights under Riley. I do not consent to a search of my device. If you have a warrant, I will comply. That is the sentence. That is the protection. Memorize it. The third is the mindset shift that changes everything. Your phone is not a neutral tool. It is a legal document you are continuously writing about yourself. Every location ping, every app permission, every search, every message that passes through a third-party server is potentially a piece of evidence in a case that has not been opened yet about a crime that has not been committed yet involving a you who has done nothing wrong. That is not paranoia. That is the accurate legal description of how your data is being treated by the frameworks currently in place. Treat your phone accordingly. Be deliberate. Be informed. Be the kind of person who cannot be caught off guard because they already understood the system. Here is why all of this matters for the long game. The founders of this country had a specific and hard-won understanding of what it meant to live under a government that treated private citizens as subjects of continuous surveillance. The writs of assistance that sparked colonial outrage were general warrants, documents that gave British officers the authority to search anyone, anywhere, anytime, without specifying what they were looking for or why. The Fourth Amendment was written as a direct response to that experience. A geofence warrant that sweeps up every device in a geographic area without naming a suspect is a general warrant. A mandatory data preservation order issued before an investigation begins is a general warrant. A bulk purchase of commercial location data that bypasses the warrant process entirely is the functional equivalent of a general warrant achieved through a financial transaction instead of a judicial one. The constitutional concern is not new, the technology is, and the answer to that technology is not to panic, and it is not to surrender your device, and it is not to assume the courts will fix everything before it affects you. The answer is the same one it has always been. Informed citizens who understand their rights, who exercise them consistently, and who hold their representatives accountable for the legal frameworks that govern them. You are now more informed than you were 20 minutes ago. Use that. Subscribe right now and turn on all notifications. The legal landscape around digital privacy is moving faster than almost any other area of law, and you cannot afford to be behind it. Drop a comment below and tell me this. Have you ever audited your app location permissions? Have you ever thought about your phone as a legal document? I read every single comment, and I want to know where you are starting from. The information is here. What you do with it is up to you.